Good morning. All things to order. Subject matter today is the imperative for the appointment of a substantive Chancellor of the Judiciary and a substantive Chief Justice in Guyana. And my name is Selwyn Peters, attorney at law in Canada, Trinidad and Tobago, and Guyana. I was the lead attorney on the successful constitutional judicial review matter, Paul Slow versus Attorney General of Guyana. I've appeared in several cases, including the case that I'm going to discuss, Fitzroy Jordan versus the Attorney General, because that's the substantive decision right now on the appointment of the Chancellor of the Judiciary and the Chief Justice. But before I launch into my discussion, there's a question. There's always a question at these meetings whether there's any declaration of bias or conflict of interest. So, in terms of that declaration, I don't have a declaration of bias or conflict of interest per se. But what I just mentioned is that I represented the opposition. I represented Fitzroy Jordan in the case that we will discuss. I also represented the leader of the opposition, Aubrey Norton, in that case that we will discuss on meaningful consultation, the content and the form of it. I also represented Christopher Jones, who is the chief whip of the People's National Congress in the Hicken appointment matter, and we will touch on that briefly because it has some content that is relevant to the appointment of the Chancellor and Chief Justice. Most of the discussion touches on how the opposition interacts with the president and the opposition leader, because it's the two of them really that has to come to an agreement in respect to this appointment. So I think the best way to do this is to the best summary of how the state of affairs is there was an affidavit filed in the case that I appeared in. I appeared in Fitzroy Jordan's case. And this affidavit here is sworn by Gilda Shearer, who is the minister in the office of the president. No, she's the Minister of Parliamentary Affairs and Governance. So she swore an affidavit in defense of Fitzroy Jordan, and she, in great detail, set out the sort of state of affairs. And I think her affidavit was true. We didn't cross-examine her on it because the affidavit of whatever she swore to was accurate. She said it is a matter of grave regret that since the Constitution of the Cooperative Republic of Guyana, Chapter 1:01, the Constitution was amended in the year 2001 by Act Number 6 of 2001, Constitutional Amendment Act Number 4, Act of 2001, Article 127, subsection 1 and 2 of the Constitution, to require agreement between the president and the leader of the opposition in respect to the appointment of the Chancellor of the Judiciary and Chief Justice. Right? So Article 127, subsection 1 requires the agreement. It doesn't require the president to simply meaningfully consult as he would if he's appointing the commissioner of police or he's appointing other constitutional office holders, that requires simply meaningful consultation. This requires more than that. This requires the agreement of them. And so she sets out the historical perspective, and she essentially said, you know, the last person to hold this appointment in the substantive way was the Honorable Madam Justice Desiree Bernard. She held the post of Chancellor of the Judiciary until 2005, when she was appointed to the Caribbean Court of Justice. And Charles Singh held the substantive position of Chancellor. So let me put it up for you here. So, anyway, what's happening is we'll go through the documents that okay, here it is. So this is the affidavit in defense that Gil Teixeira had filed in the case that I litigated the Fitzroy Jordan case. And so she started off that she gave the historic perspective. Amendments. She sets out the different discussions that happened. So President Jaggio was the president 2005. He initiated discussions with Robert Corbin, and he wanted to appoint Carl Singh as Chancellor and Eon Chang as substantive Chief Justice. And Mr. Corbin withheld his agreement. So they were acting. And when Ramatar was elected, Donald Ramatar was elected president in 2011, the leader of the opposition was David Granger. And Ramatar again tried to appoint Carl Singh as Chancellor and Eon Chang as substantive Chief Justice. And the opposition leader, Brigadier General David Granger, refused or withheld his consent. She said he refused to offer his consent. And she says, I'm informed by Dr. Barrett Jagden do firmly believes that under the term of David Granger, no attempt was ever made by the president to engage him as then leader of the opposition to secure the agreement for the appointment of acting Chancellor Carl Singh or acting Chief Justice Eon Chang. So both Carl Singh and Eon Chang retired as actors. When after the retirement, Cummins Edwards was appointed to act as chief. He was Chief Justice, and she was appointed to act Chancellor at some point. Roxanne George was appointed to act as Chief Justice. And with respect to these acting appointments, she said no discussion was initiated by President Granger with respect to these appointments. But then in 2017, President Granger proposed to the leader of the opposition that the Chief Justice of Belize, Mr. Justice Kenneth Benjamin, be appointed as Chancellor, and that Justice Yolanda Cummins Edwards be considered for the post of Chief Justice. And then she wrote, I was informed that opposition leader Barry Jagdeo she verily believed that he withheld his consent to this appointment, to this appointment. Well, he withheld his agreement because he needed to agree. So he didn't agree. And so the appointment didn't take place. So I think that set out the historical context that we need to know with respect to these appointments. I mean, what it showed is that we had these opposition leaders and the executive presidents, and they couldn't come to an agreement. The president put forward a Chief Justice and a Chancellor designate, and the opposition leader simply says, I withhold my agreement. And so you have the situation right now with Aubrey Norton, who is the leader of the opposition, and Mohamed Irfaan Ali, who is the executive president of Guyana. There's quite the back and forth, and it has gained a certain fervor within the last few weeks in respect to these appointments. As I said before, I was the lawyer for the applicant in the case that caused some declarations to be made. That case is Jordan versus the Attorney General of Guyana, and I'm going to put that decision up on the screen. So you see, we appeared before Madam Justice Daman F.J. Young, and the persons who appeared was Roysdale Ford, Senior Counsel, with Selwyn Peters for the applicant. They had the Attorney General himself, Mohamed Irfaan Ali, Senior Counsel, along with Mr. Nigel Hawk, who is the Solicitor General, Ms. Deborah Kumar, who was then the Assistant Solicitor General. They had Brianna Clark and Shoshana Lal for the state. And as you see, the judge started out her judgment saying these proceedings have been instituted after decades of failure by the president and the leader of the opposition of the Cooperative Republic of Guyana to agree on the appointments of a substantive Chancellor and Chief Justice. And then she says, this case raises issues of considerable constitutional and juridical significance. And I'm not going to go through all the discussion that she made because the decision is online. She said all the declarations that we sought in the application that we brought on behalf of Mr. Jordan, who was the vice chair and still is of the People's National Congress, a political party which forms part of a partnership for national unity and alliance for change coalition. Jordan submitted an affidavit in which he deposed that since assuming office in August 2020, the president had refused to initiate the process contemplated by Article 127 of the Constitution in respect to the permanent appointment of the offices of Chancellor and Chief Justice. So the opposition leader essentially wrote to the president a letter setting out that he wants these two people to be appointed, the acting chancellor and the acting chief justice. President Bond is saying that he'll his deliberate judgment when he's ready to engage on that issue, he will. But the judge that heard the case made 4 declarations in April of 2023. He declared that Article 127(1) of the Constitution creates a mandatory constitutional duty and obligation on the part of the president and opposition to comply with this provision. So it's not one hand clapping; it's both hands that has to clap. And I'm just citing Jones versus the Attorney General, another case that I argued in Guyana. So it has to be both the president and the opposition leader. A declaration that for as long as there's no substantive appointments to the office of the Chancellor and the Chief Justice under Article 127(1) of the Constitution, the president and the opposition leader are on the mandatory constitutional duty and obligation to engage in a process which results in compliance with Article 127(1) of the Constitution. A declaration that, notwithstanding that Article 127(1) of the Constitution does not set out any timelines for compliance with its provisions, the duty imposed on the constitutional actors by Article 127(1) of the Constitution must be discharged with all convenient speed. A declaration that any protracted or further delay in complying with Article 127(1) of the Constitution is and would be inimical to the independence of the judiciary as set out in Article 122A of the Constitution. I think what we have to understand in this case is it's 2 parties that has to come to an agreement. And it's 2 parties that have to keep talking. And let's look at what the Chief Justice said here in terms of people talking. I did another case that's important, and this case is Aubrey Norton, who is the same person we're talking about, who is the leader of the opposition. and versus the Attorney General and a few other people. This was in respect to the Integrity Commission and the Police Service Commission. And you'll see in this case again, you had Rosedale A. Ford, Senior Counsel, appeared with Selwyn A. Peters for the applicant. The Attorney General appeared together with the Solicitor General, the Deputy Solicitor General, senior legal counsels, legal advisors. So you see there. And then Dyson Randani, QC, appeared. CV Thatram also appeared. But this is what the Chief Justice said in Norton's case, which at paragraph 117, which bears repeating. Because I think the opposition leader sometimes try to, he's not seeing that his role is to move the dial forward in terms of discussion with the president. The president of the Republic of Guyana and the leader of the opposition has not met in months, probably probably for the entirety of 2024 to discuss any issue except the Venezuela issue. I can't recall them meeting to discuss anything else. And the opposition leader should be able to pick up the phone and call the president. I don't know if he's doing it, but he should be able to pick up the phone or write to the president and say, look, let's meet and let's have conversations on these matters. And this is what the Chief Justice said in Norton. She looked at the salutary words of the CCJ in both Mustafa, first the Attorney General, that was on the Patterson appointment as the chair of GCOM, and the Air Services Limited case. And then she quoted 25th, paragraph 26 of Mustafa, said the Constitution anticipates that the duly bearers and actors will conduct themselves in a reasonable and responsible manner. They will eschew partisanship, and they will seek the best interests of the Republic and the Guyanese people. That's what's up. That is exactly what is up in terms of the president of the Republic and the leader of the opposition moving the dial forward. And it's not like she didn't go through the analysis, and they have to read it because they're the people that are bound to comply with the Constitution, the president and the leader of the opposition. So the Chief Justice of Guyana went through a turgid detail of the principles that applies to the duty of to consult. And so she went through Air Services Limited versus the Attorney General et al. That went to the CCJ, Caribbean Court of Justice, our apex court, and reported that 2021 CCJ 3. And Justice Jamadar there discussed or explained what the duty to meaningfully consult means. See, so she cited it in great detail, several paragraphs of the decision. And then she highlighted at the end the principles in the context of consultation also include values such as transparency, openness, clarity, inclusivity, accountability, and timeliness in relation to both the process and relevant stakeholders. Good faith dealings are the cornerstone of good governance. It thus supports public trust and confidence. Right? So she went through this in great detail. And let's look at paragraphs 63 and 64. She says that she comes back to Air Services Limited and she says the dicta of Justice Jamadar in Air Services Limited provide guidance on the attitudinal lens regarding how consultations should be conducted. While Jamadar J observed that the onus is on the state and public authorities to initiate the consultation process and ensure that its requirements are satisfactorily met. He further observed that the consultation process requires an active engagement, neutrality, sincere receptivity, and a genuine openness to correctly understand and appreciate the recommendations. In this case, it would be agreement that's been sought. As such, the onus is primarily on the president to initiate the consultation process and to ensure the requirements set out in Article 232 are met. So there's a corresponding onus on the party being consulted to reciprocate. And then this is what she said as the banger, as we say colloquially, one hand kind of clap. And then she went to the Essequibo Cricket Board case. And then she also cited Jones versus the Attorney General and Hicken case. And I don't want to toot my own horn, but I'm going to toot my own horn because in the Attorney General versus Jones case, it's yours truly, Selwyn A. Peters, that appeared in that case again. So I've made constitutional precedent, set constitutional precedents in all these cases, as you see. In Christopher Jones versus the Attorney General of Guyana, Clifton Hicken. It's Royceville Ford appearing with Selwyn Peters for the applicant. And again, it's Mohamed Irfaan Ali together with the Solicitor General Nigel Hawk, Deborah Kumar, Asha Ramzan, and Sabira Ayel, who appeared in that case for the state. And so the Chief Justice went right back to Essequibo Cricket Board, the Essequibo Cricket Board case, and at paragraph 38, she said the decision of Chang CJ in the matter of an application by the Essequibo Cricket Board for a writ of certiorari and prohibition 2015 HC CIV EMCM2 provides a practical approach to treating with a situation where the law provides for consultation, but due to no fault of the person mandated to consult, the consultation did not or could not have materialized. And so she cites, she went through it in paragraph 39, what the situation was there. She went through the situation there. Now, this case here, you have various statements being made by President Ali, statements being made by the leader of the opposition, statements being made by the EFC. So let's listen to it and then we analyze these statements. So on the 31st of December, His Excellency Mohamed Irfaan Ali posted press conference. See, going to the part of the press conference where Dennis Chibral asked the president questions, and you'll see a person looking exactly like me sitting right behind Dennis Chibral with my feet crossed over. But I was there at the president's press conference when Dennis Chibral asked a question about the appointment of the Chief Justice. So we'll listen to it, and we'll listen to the president's response to it. So
that has no impact on the appointment of chancellor from my perspective. Now, I would say that no, this the process there's a process to follow, and as a president, I would follow the process.
So that was the full statement. Let me just end this speech from the president. But that was the full statement of the president in respect to the appointment of the chancellor. Excuse me, I picked up a call at the same press conference. So I'm battling that. Sick. But you'll remember that what the judge said in paragraph 41 of the Viceroy Jordan case is that the president and the leader of the opposition should have moved with all convenient speed and that no further delay or excuses ought to be countenanced. I'll show, let me pull that up. Pull up paragraphs 41 and 43 so that you see it, because this is a serious issue. But it's two hands that got a clap, right? The leader of the opposition and the president. And the leader of the opposition has remedies available to him. If the president isn't acting with all convenient speed, and if he doesn't make use of those, remedies or forums that are available to him, then who do you blame? You have to, the blame has to fall on him too. For this sort of willful non-compliance with this, the directions of the Chancellor of the Judiciary. This is what she said. Justice Damon Young said the period referenced by the applicant upon which his claim is based is stated to be from August 2020 to April 2022. However, from the evidence put before the court for much, if not all, of that time, the leader of the opposition was not prepared to enter into any engagement regarding any appointments. See? The leader of the opposition was not prepared to enter into any engagements regarding any appointments. There's no doubt in the court's mind, and there's no evidence which persuades the court otherwise, that the stance of the then leader of the opposition contributed to the delay now being complained of by the applicant, who himself is a member of the party in opposition. So evidence suggests that it was only from April 2022 that the current leader of the opposition indicated his interest in consulting. Therefore, by all accounts, the way is now cleared for this engagement to commence. And then she says this, and no delays or excuses ought to be countenanced. Right? We're talking this decision was when this decision was. This decision was the 26th of April, 2023. And we were talking on December 30th, December 31st, 2024, more than a year and a half later, and the needle hasn't moved 1 inch. Let's look at paragraph 43, what she said. So it's both the president and the leader of the opposition moving at a slow pace, and both of them not fulfilling their constitutional responsibilities in this regard. She said, for too long, Guyana has been without substantive office holders for the two top positions in the judicial arm of the state. A situation which continues to be untenable and unacceptable to the citizenry and inimical to the independence of the judiciary that the supreme law of the land provides for. Any further delay in commencing this process should be eschewed so that this, and then she quotes, significant blot on an otherwise impressive Guyanese legal and judicial landscape, end of quote, is not perpetuated further. Right, so she did that, and then she found that the president wasn't in breach, but she made these 4 declarations. And of course, like I said, the 4 declarations were not complied with. So let's hear what the leader of the opposition has to say in his own words, because he was on Nation Watch. And he was asked by Marvin Williams. I'm going to play the whole statement that he made. Some of it had inflammatory remarks, but he's the leader of the opposition. He's accountable for any words that he says. Official capacity. He doesn't have the immunity that the president have on the Constitution. But listen to how he responded to so listen for whether there's the analysis. Well, let me let you listen first, and then I'll comment to that.
I think your agreement on a point. Yes, already almost former president is not president. there one of them is, and there is no consideration for appointment. What is wrong with the thinking of the People's Progressive Party when it comes to qualified, certified professionals? And how is that going? How is their position going to? So, like I said,
So what I've done is I've played the entirety of the leader of the opposition response to Marvin Williams and Nation Watch. I mean, there's no reason why Aubrey Norton should have referred to two very senior jurists who are the acting Chancellor of the Judiciary and the acting Chief Justice as these young ladies, these two young ladies. They're two experienced jurists. They're not two young ladies, they're two experienced jurists. And so, if you want to get respect, you have to treat other people with respect and call them by their right names, right? Madam Justice Janet Cummins is the acting Chancellor of the Judiciary. Madam Justice Roxanne George is the acting Chief Justice. To refer them as two young ladies is simply infantilizing them, right? And then, you talk about the PPP appointing people who are compromised and violated the law. You would have to point to any person in the judiciary in Guyana. You'd have to provide evidence to show who within the judiciary is compromised and who within the judiciary has violated the law, because we're talking about appointing the Chief Justice and Chancellor, right? I mean, and then he spoke about so Marvin Williams spoke about no line separating the judiciary from the government. I mean, all these statements sound inflammatory to me because, quite frankly, to be quite blunt, I mean, you're the opposition leader. I mean, Barrett Jackson did a better job in Mustafa than you're doing as opposition leader right now. Because when the Patterson case came up, Barrett Jackson, in response to the president, provided names and provided CVs, right? And provided a factual foundation so that when the case went upwards to the CCJ, there was a proper factual record so that the CCJ could have overturned the decision that President Granger made to appoint Justice Patterson. So he was getting proper legal advice in terms of how to build a factual record that can withstand scrutiny at the highest level. I mean, you have to reach agreement with the President of the Republic, and the leader of the opposition has to reach an agreement on the Chief Justice and Chancellor. And there's nothing, regardless of what the qualifications are of Roxanne George, or regardless of what the qualifications are of Madam Justice Janet Cummins, there's nothing that precludes the appointment of two other people. Not because someone is acting in a position means that they have to be appointed to the position. I mean, and that's what the Chief Justice spoke about in your case, Norton, at paragraph 117. If you want to reach agreement, there's work that has to be done, right? There's work. There's work that has to be done, and this is the work that has to be done. Right? Citing Mustafa, the Constitution anticipates the duty bearers and actors will conduct themselves in a reasonable and responsible manner, eschew partisanship, and seek the best interests of the Republic and the Guyanese people. This name calling and stuff that you went on with a few days ago, how does that meet that test? How does it meet the test? And let me say this clearly. We used to say in negotiation there's platinum. You know, in negotiations, you never get everything you want. And the truth of the matter is, you, Aubrey Compton Norton, and you, President Mohamed Irfaan Ali, can make history. Because since 2005, there was no substantive Chief Justice and no Chancellor substantive appointed. That's 20 years ago, 2 decades ago. The two of you can make history by appointing a substantive Chancellor and a substantive Chief Justice. And quite frankly, both of you are responsible people. It doesn't have to be those two acting office holders. I mean, the president can put forward his list of people who he thinks are fit and proper to be Chancellor of the Judiciary, and who he believes that are fit and proper to be the Chief Justice of the Cooperative Republic of Guyana. And the leader of the opposition can do likewise. But to simply be fixated on the two incumbents who are acting, it doesn't move the needle forward, and it doesn't act in good faith. Because the president does not have to appoint them to substantive positions if he believes that there are other people who should be appointed. That's what happened with Kenneth Benjamin's situation with President Granger. He didn't believe that he needs to appoint the two substantive office holders as they were. You know, he wanted to appoint someone else. And so the two of you can come up with your own list. And you can agree. You're both two adults. One of you get your choice as Chancellor, and one of you get your choice as Chief Justice, and you agree on it. That's what negotiation is about. If you have to reach an agreement, you don't get everything you want, and everyone comes away unhappy with something or the other. That's how negotiations are. And so people have to get their act together, and people have to act judiciously, because I don't think the comments that Aubrey Norton makes move the dial forward on this issue. And people have to be honest. People have to be quite honest to say what I just said, because that's how the needle is going to move forward. The president does not have to appoint the two actors. He can suggest any names that he wishes. Norton can suggest any name he wishes, and then they engage in a process of negotiation to resolve that impasse. That's how that impasse is going to resolve, that has existed for 20 years. I mean, the constitutional provision is rigid, but it's rigid because it wants y'all to sit down in a room, eyeball each other, and reach a consensus. And then you sign off on the agreement. That's my take of that. I mean, but let me say this. There has been progress in Guyana. There has been progress. There is now a fully functioning Judicial Service Commission. There are 10 judges who were recently appointed to the High Court. There were vacancies for 6 judges on the Court of Appeal, posted in May 2024. Applications were received. They were the vetting of qualified candidates. Those candidates were interviewed by the Judicial Service Commission, and the executive president has or may receive a list of suitable candidates from the Judicial Service Commission from which he can appoint on the advice of the Attorney General and Ministry of Legal Affairs. Right? So with a fix in the judicial shortages at both levels of courts, the building and the provision of more courthouses and courtroom facilities, the hiring of more judicial staff nationwide, the provision of accommodations to house the jurists who are going to be traveling to various locations to preside. Then the order of business for 2025 prior to the government going into election mode and the opposition as well. Maybe another meaningful set of engagements between the executive president and the leader of the opposition in respect to the substantive appointments of the office of the Chancellor and Chief Justice, right? Because the Bar Association and the posture of what's happening right now illustrates what the Bar Association said a while back. This is a Dennis Chabral article, and he says, Bar Association recommend changes to the failed formula for appointing the Chancellor and Chief Justice. Right, and Pauline Chase had, who was then the president, she said, I'm quoting, I urge, I call on those who duly so failed to start the consultation process and put into motion the machinery to address the correction of this unworkable and failed formula, right? And then journalist cites the Constitution, and he said exactly what the judge said in the Jordan case. It is inimical to the rule of law that they are acting appointments of our highest judicial officers. The absence of confirmed judicial officers since the amendment of the Constitution for their appointments some 20 years ago is no clearer evidence that that system is not working. Right? And then she said that it's an embarrassing state of affairs that need to be swiftly corrected because it adversely affects our standing in the world in the rule of law index and as a democratic society. And then the article cited that the president of the CCJ at the time, Sir Dennis Byron, frowned on the protracted delay in the appointment of a substantial Chancellor and Chief Justice. So, I mean, 2025, if both of these office holders act with the alacrity that they should, act in a responsible manner, then you'll get these appointments that are quite fit and quite proper for the purpose. And of course, this is my first live since we broke 2025, and I want to wish everyone a happy and a prosperous new year. Thank you very much.